Tim Cowen. Welcome to Digital Markets Research Hub. You have a long and established career in competition law, and relatively recently, though, you have focused on one of the most vibrant, one of the most dynamic, and probably one of the most important digital markets, namely regulatory aspects of edtech and cases related to edtech. So while talking about different aspects of competition and digital markets, I wanted to begin with inviting you to maybe explain to students and remind to others about the key elements of this industry and why it is of such pivotal importance.
Okay, it's a big question. In terms of why it's of such importance, we did some work recently which shows that if you think about the amount of money that people have to spend every day in the UK, the amount by which you overpay has gone up in the last 5-6 years. So based on CMA figures, we worked out that it's certainly over £1,000 per household in the UK that is increased because of what's been happening. So that should kind of capture people's attention. But let me just go back a bit, because you asked a question about, or you made the point that I've been focusing on this more recently. I think it's important to understand how the technology layers work. So there's really three that I wanted to cover. The first layer is telecoms, and that's very old. So, you know, the wires and the boxes that are in the ground, which go to every house, they've been around for over 100 years. So my, start in this sort of technology space was, I worked for BT. I joined BT in the early 90s. And you start to understand something about the scale of the technology because it's global. It was built over 100 years ago. It's built out of copper wires. There are switching centers. It was built as a tree and branch network. So you used to see in old films, they used to take over countries by attacking the central switching centers. And so if you're looking at how to control communications, the communication switches were the first place people went to. They also went to the broadcasting stations, obviously, as well. But in those, go back 50 or so years, established communications networks were in place pretty much everywhere in the Western world. They've taken longer elsewhere. So, and then, of course, in the 80s, we had the development of mobile. So that was really somewhere where the UK was really the first to develop mobile communications. And so we in the UK had what became O2 now, which was Cellnet. That was part of the BT group, and Vodafone. And they expanded globally, but they only expanded because regulation allowed that to happen. So when I first started in telecoms, there was a national monopolist, British Telecom, in the UK. It had been opened up to competition by a ideologically pro-market Thatcher government, right? That wasn't the case in continental Europe. There was still only one France Telecom in France and Deutsche Telekom in Germany, and so it goes on through each country across Europe. But under the 1990 liberalisation directives, which are European Commission directives, they required markets to be opened up. And that's based on European law. It's based on the freedom to provide services across Europe from anywhere. So one of the many things that Europe has given us is a open, competitive communications market. And that provides, if you like, layer one. So the first layer is the underlying infrastructure. And then you have people being able to provide services across that infrastructure from anywhere to anywhere within Europe, early 90s. Working in BT, my job was to explain to regulators what the benefits might be of having communication services being provided by a variety of different players rather than a monopolist. And many of the people I worked with at the time were banks and financial services organizations and computer companies, because what they were doing was providing private data networks. So if you think about foreign exchange trading, you think about the underlying trading platforms where people are trading billions of dollars. You know, if you look at the foreign exchange markets, that's dollars. If you look at commodities exchange, it's commodities, and so it goes on. But all of that takes place between computers, trading as fast as possible the relevant components that are subject to the trading regime. And obviously, if you've got different communications providers, you have different speeds of transmission, you have different resilience, you have different latency. And those things are really important for foreign exchange trading, because the quicker the trade, the more money you make, or less. I mean, it can be either way. So communications infrastructure developed in the 90s, really fueling the growth of global financial markets, which were also liberalized at the same time. And that was part of a Western European growth philosophy. So governments were looking to increase growth and expand their economies, which is, you know, that's happened enormously. So the second layer in this layer of the three layers of how the technology works is the TCP/IP protocol. So that's the internet. Now that allows for routing. So instead of having centralized switches where, you know, you would have had electromagnetic, it was originally a bunch of people plugging things into, you know, if it's number wants to call so and so at such a location, can you please put me through? And you had people putting people through at switchboards. Well, that got developed into electromagnetic switching, and then eventually digital switching. And that was replaced or gradually overlaid, I should say, with a routing network from the mid-80s. It was originally developed by the Defense Research Administration in the United States. So DARPA helped create the internet. Why? Because if you blew up a communications network in a war situation, you could then route the traffic and the communications around the fault in the network. So it was built really as to increase resilience so that communications could take place more effectively in times of war. So that's the second layer, that's routing. And that enables packets of data to be transmitted in different directions and then can be reassembled. So you can send a message simultaneously from London to New York via Spain or Iceland, you know, or via satellite. You know, you can go lots of different directions. Now that's creating a layer of data networking, which was still run by communications companies, but also companies like, you know, back in the 90s, people like EDS and IBM were extremely big in that game, and BT went global behind the financial services markets. So by the time I left BT in 2008, we were running the financial markets. We had a very big proportion of all trading platforms in London, New York, Paris, Frankfurt, Tokyo. So that was what we built as a global data networking capability. Now, governments had got rid of the monopolies and enabled trade because of the feed and provide services under the European Treaty. And then we had the issue that the incumbent monopolists didn't really want competition. So from a personal point of view, I then, as a competition lawyer, found that my world was full of cases against players like the Dutch telecoms organization, who had a kill the competition committee. So we took case after case against, in France, we took a case in the mid-90s where I worked with an associate of mine, Ronnie Preiskel, who later went off and set up the firm that I'm now in. So we took a case, well, you can tell it was a long time ago because we recovered 4.4 million French francs in damages for BT in France against France Telecom for blocking the ability of BT's outside broadcast network from providing services for races and outside sports events in France. So that was an abuse of dominance case. And there's been a lot of abuse of dominance cases ever since. But in the late 90s, I worked with a group of people from AT&T, the US government, the British government, to persuade countries to open up their communications infrastructure to even greater competition worldwide. And that was the WTO telecoms package, which was agreed as part of the late 90s, 1998 package, which became the European telecommunications package domestically across the whole of Europe, which enabled communications infrastructures to be further opened up, and information services. So the third layer, the top layer, if you like, are services which have been provided by a wide variety of different players, which are basically data services that have given rise to the sorts of things like Facebook Messenger originally, Skype originally in the early 90s. You had voice and data, but then it became video. So video networking, like we're now on Zoom. I think Skype was bought by Microsoft and is the basis for Teams. So that was a video networking, one of the earliest video networking functions. It's communications. It's a data communications application that runs over the top. And in the telecoms world, they're called the OTTs, the over-the-top companies or applications that are running over the top of the network. And the businesses that have been built on the back of that are businesses like Facebook and Google and Apple. So they've created platforms at the third layer at the top. So this is all interconnected. It all works together. And if you can restrict or create choke points over the supply chain, as has happened with the browser access through the smartphone from 2010, Apple has a choke point. It has the ability to limit what you can see online. Google also the same, because it has control over the browser in the smartphone. So that's how I ended up doing these cases on technology in Google, Apple, Facebook, etc. Essentially, to my mind, it's a natural progression from just understanding the technology stack and how it can be restrained and how competition can be restricted across that stack.
Before moving to or coming back to EdTech, and because there is very clear continuity in terms of how the technology enabled actually the mechanics of programmatic advertising in particular, I wanted just as a kind of side question to ask you about the role of net neutrality in this game, because I imagine at some point when the dominance of telecommunication industry was so self-evident and the newcomers into this digital universe were considered as small companies in garages and or university dormitories who are proselytizing the world with a new reality, so to say. And the ethos and the pathos of net neutrality was very powerful. Was it somehow used by the current big tech players to scale up? And how do you, looking historically, evaluate its role?
So net neutrality came up in the early 90s and then became an issue as we got into the early 2000s. It was a concern by over-the-top companies or applications that the network operator could throttle, right? Control, restrict, limit the bit rate that would be transmitted between the consumer and wherever the app was hosted, right? And clearly, when you're building networks and you're running your own applications over them, you have an interest in making sure that your own application works better than somebody else's. So an example in the UK would be BT running its own broadband network, because BT owns and controls the underlying wires. It could optimize its own broadband application in a way that it transmits a faster bit rate, or it allocates more to video than voice, or operates in a particular way that would benefit its own broadband service over a competitor like Sky or TalkTalk or all the other competitors that came in building their own overlay networks on the top. The real debate started in the States, though, because under the Federal Communications Act of which goes back to the 1930s, the FCC imposed obligations on any common carrier. Forgive me for actually clearly showing how much of a competition law nerd I am. The FCC's common carrier regulation is based on the English common law. So we in England, and you now, Oles, you now have the ability when somebody says to you, what does what you do have anything to do with life, the world, and everything, and the price of a pint? I'm going to give you the answer, right? So I've told you about the price of what people are paying is overinflated because the over-the-top companies are raising pricings for advertising, which is borne in, the price of your insurance, your car hire, anything that you buy or sell online is overpriced because the advertising has been raised. And that's because of deals between, for example, Apple and Google, which inflate the price of online advertising. We can come back to that. That's a matter in a current case. But going back before the FCC and looking at net neutrality, the FCC's basis for its jurisdiction is common carriage. Common carriage is a common law principle that goes back to the Middle Ages, that if you were a drayman, so a dray and horses you might see on the sign of a local pub, is a flatbed with a few with wheels, and the horse pulls the dray. What's on the dray? Well, it's anything that you as the villager in the Middle Ages would want to put on it. And the drayman as a carrier was required not to charge a prince or a pauper a different price, because obviously you could have charged a higher price for somebody who had a greater ability to pay, but that was regarded as unfair under the common law. Hence the common carriage. Now, if you look at the common carriage jurisdiction, that's the basis for anybody holding themselves out as a carrier. So that progressed from drayman to postal services through Pony Express. There's even an example of somebody who's carrying you at Disney in the States. There's a big case on that 2 or 3 years ago called Net Choice, right? The Net Choice case went to the Supreme Court in the United States about this because Texas and Florida said, look, we think that those businesses like Facebook or Google are holding themselves out to the public. What they are doing is providing a service. They shouldn't be allowed to discriminate. They should be subject to the common carriage principle. And that became an issue of whether the states at state level in the United States, whether it's Florida or Texas, could regulate on that basis or whether it was a federal matter. Okay. Donald J. Trump is one of the people who actually intervened in that case. So it shows some degree of interest. I don't suppose he wrote the brief himself, though. Anyway, that is the common carriage history. What's that got to do with the price of a pint? Well, it's basically the same principle. If you hold yourself out to the public, you can't charge a prince more than a pauper, which is the basis for the public house, because it's holding out to the public, and hence you can't charge more for one than the other. There's a whole load of equally intriguing provisions in our common law about things like engrossing, forestalling, or regrating, which were the offences if you sold outside a marketplace, you were put in the stocks. So if you look in old English market towns, you have these stocks which have got a head shape and places for two hands, and people would pelt you with rotten food. And the reason for that was that if you sold on a market, the price of the market would prevail. So it created fairness, and that would enable, if you had tomatoes and tomatoes ripen at the same sort of time, obviously if you sell on the market and there's lots of other markets there, then the market price will be in equilibrium because there's, Tim's tomatoes, Ole's tomatoes, John's tomatoes, they're all there at the same time. So the price of tomatoes would go down, but everybody bears that price. All right. So if you forestall a market, you sell outside it, you make more money, right? Well, what happens to the people who've got their tomatoes all sitting there not being sold at the lower price? Well, they go rotten. So they used to pelt people with rotten fruit. if you sold outside the market. So that is a very ancient common law principle, which is the basis for our competition law and the net neutrality law. The net neutrality law is based in FCC jurisdiction. It was about preventing telecoms incumbents from restricting applications. So they had to treat everybody equally, non-discriminatory, and they had to be neutral in their treatment. The actual expression, I'm told, was created by a much younger Professor Tim Wu when he was working with a much less profitable and smaller Google back in the early 2000s. But I probably can't find you evidence for that. You could ask Tim if that is actually the case, but that's one of the stories in the industry. Of course, now what we are thinking about is, well, why shouldn't we impose the net neutrality principle on the over-the-top players? After all, they've effectively substituted as communications providers for the old communications companies. They're providing the handset, the service, the messaging platform. They are carriers. And so why shouldn't they have the non-discrimination obligations imposed on them? Personally, I think they should. I co-founded the movement for an open web 5 or 6 years ago, and we have put in applications to the FCC that would suggest net neutrality should apply to the over-the-top players. I think it's really a difficulty of US politics, though, because FCC is subject to Congress, and you'd have to get an agreement, and you'd have to be subject to. You might need to make an amendment to the law, which would be difficult. It could be a matter for interpretation by the FCC itself, which has rulemaking power, but that's likely to end up in litigation. It always has in the past.
Let us then use the structure which you have so eloquently and competently highlighted, the background, the historical context, which is so important to understand the very technology and the business model, so to say, but also kind of engineering mechanic to ad tech industry and to programmatic advertising. We have few landmark cases in major jurisdictions, trendsetters. But before looking at the cases themselves, please extrapolate the background which you have highlighted to us to the business of ad tech and explain its importance and the stakes.
So if you go back to I was explaining, the boom that took place after the internet was created, you then had the hypertext links applied in the World Wide Web. So Tim Berners-Lee is sitting around as a professor in CERN in Switzerland, and he couldn't find his documents because he hadn't filed them properly. This may be a common problem. So what he did was he took the hypertext link, which was already in existence, and he created hypertext links to documents. So what you can do is to search for documents using a hypertext link. It gives you the URL. That was the big insight, which is why he's now Sir Tim Berners-Lee. He created the World Wide Web. Hopefully people now understand the difference between the internet, which is a protocol, and the World Wide Web, which is basically a bunch of hypertext linkages, right? So you can connect this computer to your computer using hypertext links. That sets up a session. So the computer session is in progress at the moment. There is a transmission taking place backwards and forwards as we speak, right? Now, what you're using is a bunch of communications protocols that enable that to happen. So there's bitrate transmission. There's a lot of video codec activity in this sort of a transmission. But it wasn't initially possible to do that. So if we go to something, there's lots of technology involved in just this call taking place. If you go to the kind of, let's say, 98, 2000, sometime about then, these were all in the process of developing. And one of the main problems with video communications, just as an example, is it was extremely expensive in terms of usage of the underlying bandwidth in the network. We used to charge per minute phone call charges, which became per minute data charges. So in the early 2000s, that was still the case. What happened with the over-the-top data transmission businesses is they didn't charge that way at all. And if you've got businesses that are being funded by advertising, they can be free at the point of use. So people have got extremely used to the idea that this internet stuff that you get is all free. Well, it actually isn't free in the sense of it costs money to produce. It's very expensive to produce, but it's free at the point of use and funded by advertising. So if you wheel forwards from about 2000 to maybe 2007, 2008, a company called DoubleClick had developed a thing called the DoubleClick ID. And the DoubleClick ID was widely used. About 60% of the market was using DoubleClick IDs, which allowed the matching of the person who wants to advertise with the person who's got spare inventory. So online, if you want to advertise, you've got an advert, you want to advertise, you need to match, you need to have a match key. And the DoubleClick ID was the key component that enabled the matching of supply and demand across an advertising exchange. But it was the DoubleClick ID that was very widely used. Google bought DoubleClick, right? I was at the time acting for a competitor. We said this is an outrage against humanity. It's going to cause a massive problem because Google will be able to monopolize online advertising. It's extremely dangerous. You mustn't let it happen. And that went through the American authorities. There is a fantastic dissenting opinion from a lady called Pamela Jones Harbour, which I recommend people look it up, because she said that at the time, this is about 2008, I guess. What Google does is it understands our needs, wants, and desires, because it has the ability to understand everything that you're looking for online. Not only does it control of through the browser, but also the search engine. And if you can then link all of that data together with IDs, that could cause real problems. Anyway, the transaction went through, and what Google did immediately after the transaction was to block the use of the ID. So that's really the beginning of what is a series of you can call it a single continuous infringement under competition law, or a series of interrelated technological steps. We've described this to the authorities as a staircase of harm, because each step builds one on top of the other. So you have the DoubleClick ID, which Google blocked off. Third parties then found a way around it. So this is publishers, the newspapers, found a way around it. So they didn't get locked into the Google system. They prevented advertising going to the Google system, because their advertisers, they're competing with Google for ad spend, right? So you need to be very good at online advertising. So a lot of the newspapers and other publishers, newspapers, magazines, journals, all of the different websites that are available online are competing for ad spend. And they found ways of avoiding the Google system as an alternative, providing an alternative channel to market for advertisers. Google monopolized, raised prices. The alternative players brought in a thing, which I'm not going to go into the detail of. It uses JavaScript, but essentially what that group did was to create a thing called header bidding, which bypassed Google. That allowed prices to drop. Revenues went up by about 60%. This is between 2014 and 2018. Newspapers at that time were doing quite well, right? Google then decided to block that, because it has enormous control over all of the ads that are generated by Google search. So when you're trying to be found, you buy AdWords. So if you're I also chair a small museum in the Lake District, and we need to buy AdWords in order to be found online. Otherwise, nobody will find you. There isn't a local newspaper that's going to promote you very much anymore, and everybody looks for everything online anyway. So you have to be found online. So you have to be on Google, you have to be on Facebook, you have to buy ads on those platforms. Otherwise, you're invisible, right? What the newspapers were doing was trying to offer their own online advertising space as a vehicle for the ads. Google is very effective at selling small ads through AdWords. So in response to a search for museum in the Lake District, hopefully the Armit Museum will pop up, right? But that's because what you're trying to do is to buy a museum in the Lake District as an AdWord, because it helps you target the advertising to people looking for that type of thing. Now, that battle has gone on for the last more than 10, 15 years. What Google did was it used its volume of purchases and its ability to match ads with advertisers through the advertising exchange. So the latest cases, there's a European Commission case, there's a CMA case, and Judge Brinkma has just decided the ad tech case in the US. That's really about Google's control of DoubleClick and then its control of the advertising exchange. As the biggest purchaser in the advertising exchange and the owner of it, it gave itself a first look on the bids in the ad exchange. And then because it didn't feel that level of cheating was enough, it then gave itself a last look on all the bids, so it could then cheat on bid matching, which manipulates the exchange. You can imagine it's just like a stock exchange. You can see the bids, you can see the asks and the payments and pricing, and you can give yourself a first look. You can then give yourself a last look, which just enables you to manipulate the whole thing. So Google effectively blocked and prevented competitors from being able to compete. Of course, prices start going up, and advertisers are kind of locked in, so they're stuck. That gave rise to, ultimately, they then imposed a thing called dynamic pricing. So they did 3 or 4 different things, which led to the DOJ's case, which was filed originally under in I think about 2020, 2021. So it's taken a long time to get to court because you've got the search case as well as the ad tech case. Search really deals with the monopolization of online search, which is the monopolization of the AdWords and the demand for ads. So that decision came out on August the 5th last year, where Google was found to have monopolized online search by entering into a series of agreements with Apple. So it restricts Apple from developing its own search engine. It restricts Apple from developing search access points. So one of the big restrictions under that agreement, which is wholly anti-competitive, there's no redeeming features for this, is that you might have been able to use Apple's Siri, use Ask Siri. You could have used that to search. No, that's being restricted by agreement. So Apple doesn't get any benefit out of that, and Google gets a huge benefit. Now, you just rubbed your fingers together. Why would Apple do that? Apple could have developed its own search engine. It could have been doing great things in search. It could have been a more effective competitor in search. In the case, we find that it did look at developing its own search engine in competition with Google and said that's going to cost it 10 billion a year or something, really expensive to do. And so there's a deal between Google and Apple. And if you're Apple and you don't have a search engine, you would expect to pay Google, right, for its search engine. I mean, after all, it's supposed to be the best in the world. Not at all. When we first heard about this about 2 years ago, which came out of disclosure in the search case, you had to read it twice. It's not Apple paying Google, it's Google paying Apple. And that should really raise concerns because Google pays Apple basically keep Apple out of the search market, but it also pays Apple for data. Right. So what it gets is unique access to all Apple users' searches. Right. So it's the default service provider for search. Now that means that it knows everything about Apple users' interests, wants, needs, wants, desires, and it can monetize them through advertising. So the way the payment works is that Apple gets 36% of the revenue from advertising that Google generates off Apple phones. This is a cartel. There's no messing about. What it does is it enables Google to raise price, right, which it has done by 40% or so over the last 5 or 6 years. And Apple gets, for every dollar, pound, or any other currency you like that Google raises price, Apple gets paid more. So it's in Apple's interest for there to be no competition at all with Google, that Google gets presented on all Apple products with its own special little search bar. That's Apple computers. It's the default setting on phones. But all of the navigation systems and all the techniques enable you to go very, very swiftly through to a Google search, right? So Apple gets paid 36%. When the judge did the original calculation on that, which was 2020 numbers, it was worth over $25 billion a year, right? The numbers, Google's numbers are now up to 90 billion a quarter, and that's up 12% in the last quarter. So on a conservative basis, it's probably 40 billion a year or more money than Apple makes out of making computers. Right, more profit than it makes out of making computers. It's an astronomical amount of money, and it was never disclosed to the stock exchanges or the shareholders, or nobody knew this was coming out of an agreement with Google. So that's pretty outrageous. But that's really at the front end. So that's been found to be illegal. The DOJ is currently looking at remedies, and the remedies include things like creating new search engines that are going to compete with Google in the provision of search. And then that's going to hopefully give rise to competing alternatives to the advertising, so that you have different search engines, different search text ads, and that's going to bring prices down. But that's going to take a bit of time. What Judge Brinkmar did was she dealt with the double click advertising exchange manipulation by Google of these layers in the ad tech stack that Google was able to put in place, mainly because it has this huge market power because of all of these AdWords that it sells, all of the power over the end search, because it's got 90% of worldwide search. Actually, I looked at that recently when one of the first decisions came out, which was Google's abuse of dominance in search by the European Commission in 2017. They had 90% of the market. In the UK in January this year, it's 93%. So it's actually managed to go up a bit. But anyway, yes. So that's where the core market power is. And so the ad tech case, which was decided by Brinkmar just before Easter this year, that's now looking at remedies as well.
Let us pause here on remedies, because it looks that history of antitrust in general and European competition law more specifically counts on several examples where the theory of harm was very meticulously developed, and the abuse was established and fine imposed, but remedies were somehow on the secondary importance, and their effectiveness was questioned retrospectively very much.
Mm-hmm.
It looks now that in both of these US cases, the remedies are being tailored in a probably more advanced fashion, taking into account the previous shortcomings, perhaps, of the previous models. Can you elaborate a little bit on this?
Yeah, sure. So if you look at the European and UK approach to remedies, the first thing that you got to think about is that you look at the harm to the market that has taken place. So you need to rectify the harm to the market. So if somebody has distorted the market, the idea that what you've got, which is a tort, which is unrectified harm, that's not acceptable. What needs to happen is there should be a rectification of the market. Now, obviously, the market has moved on if your case has taken a long time. So what do? If you take the Microsoft case, one of the problems in that case was about bundling. So you're combining the Windows Media Player with the operating system. Well, if the bundle, you can only take Windows Media Player. You can't have anything. If you want the operating system, you have to have the Windows Media Player. Well, you can unbundle and then give choice. So they created a choice screen. It didn't really work, right? You could have operating system choice screens so that you had an alternative to build a different operating system. That didn't really work. That's now built into the Digital Markets Act. We're going to have choice screens. Look, they don't work. Right? I don't think that's a very sensible approach to remedies, because it's a very theoretical idea that if somebody hasn't had a choice and you give them a choice, you're then going to rectify the market. If you focus on market rectification, what you should do is test. a change and see whether or not it works. You don't need to do a one-off. There's nothing to stop an authority from saying, okay, why don't we try this and see if it works, right? That should be done. The CMA has proposed that. They proposed that in their online markets study in 2020, which is also known as DAMS, Digital Advertising Market Study. And testing and trialing would seem to be an obvious thing to do by way of a remedy. But just sticking with Microsoft for a moment, it's quite an interesting precedent, because before that, if you go back to the 90s, the commission wasn't very shy about saying, we think the following would be a good thing to do. Right. So if you look at access cases, there's a bunch of access cases. One of the most well known is the BNI Lines case, where Sea-Link Rail, which is the railway from Liverpool to Anglesey, owned and operated the ship, which was the ferry that went from Anglesey to Dunleary in Ireland. And a new entrant came along who'd built a new wave-piercing catamaran. The catamaran is huge. I mean, it takes cars and everything. It's a car ferry. But the difference between the catamaran and the boat is that the catamaran gets from England to Ireland in about 3 hours, whereas the boat took about 9. I know, I went on it. It was awful. And what the boat did was it had a schedule to turn up at the port at the same time that the railway was, offloading its passengers. And, Sea-Link said, we're not going to interconnect. We're not going to enable the port to be used by a competitor. And John Temple Lang, who was in charge of enforcement of the European Commission at the time, said, of course you're going to do this. You have an obligation as a dominant operator to propose remedies. You can't just sit on your hands and say no. You're in breach of your duty as a dominant operator if you do nothing. Now, this, I think, has been overlooked. So what happened in the Microsoft case was that the commission didn't actually try and prescribe remedy or come up with a remedy. What they said to Microsoft, and I'll explain why they did that in a minute. They said to Microsoft, you come up with a remedy and we'll tell you whether it's good enough. And this has become kind of standard practice ever since, because the worry was that, and Microsoft came up with 2 or 3 different alternative remedies, and eventually there was a settlement agreement, and that didn't work. As I've said, it didn't really solve the problem, but it was the best offer that they had. Now, the worry there is that whatever the remedy is has to be proportionate to the problem. So if you're a competition authority, you can identify the problem, you can identify, as you said earlier, the theory of harm, you can refine what you think the problem is from an antitrust point of view, but you're not very good at building products. You know nothing about software. You don't know how all this works together. And the idea that you're going to be any good at that is probably, you're probably quite safe to say it's sensible not to get into product design. All right. I think they overstepped the mark with the choice screen, because I think that is a type of product design. You can offer different features and functions of products without offering a choice screen. I buy brown shoes by comparison with black shoes, or tennis shoes, depending on what I want to use them for. So if you can get the supplier to provide different features and functions, consumers can make choices between the features and functions without having to be given a boring old screen and click on it, and that just creates friction and annoyance. I don't think that was thought through, because the authority looked at it and went, "Oh, that looks like a reasonable alternative," and it wasn't. It just created annoyance, and people went with what they knew. So, yeah, what we've talked about is the need for proportionality at the European side. It's a bit different in the States, because in the States it's expressly the case that it's not just rectification of the market, but that the player that has obtained the benefits of anti-competitive activity, they've monopolized the market, they've raised price, they've got huge profits, they are required to disgorge the fruits of their ill-gotten gains. So one part of any judge's remedy in front of the US courts, the judge can think about, well, what can I do which is going to rectify the problem and also make sure that this harm doesn't provide a benefit in and to the monopolist in the future. So they can impose obligations which deprive the monopolist of the benefit that they've received. And to some quite considerable extent, that's the role for damages, that those who've been harmed can come along and they can claim. But the problem you have in many of these cases is that millions of companies have been harmed and only a few have survived. So there aren't that many around to bring a damages claim. And the harm is also to the consumer through loss of choice. And that's quite difficult to compensate people for. So the harm and the gain are not in balance. The harm gives rise to a profit in the monopolist, which isn't going to be addressed through a damages regime based on tort. Right. Now, that should be the role for fines, but we've made a big mistake on this. We cap fines in relation to turnover. It should be in relation to profit, shouldn't it? If you want an incentive to change somebody's behavior and they make a 40, 50, 60 return on capital, percent return on capital, and you say the fine's going to be capped at 10%, it's just pay the fine and move on. There's absolutely no disincentive there at all, because your profit is much higher than the top level of the fine, and the top level that never gets imposed. So I think we've got an imbalance of incentive in the remedies, and I include in that fines and penalties, because they're never enough. I mean, we've seen, I think Google is on something near 9 billion euros, but they made 90 billion euros in the last quarter. It's a small fraction of a percentage that they've been fined. It's like loose change. Doesn't make any difference. So the remedies need to rectify. They need to create competition. They need to do something about ensuring that competition can prevail in the future. So what's happening in front of literally as we speak, there's a hearing on this in Washington. The DOJ has proposed a revised proposed final judgment. And what that goes to is, first of all, there's a series of agreements. So the agreement should be banned, right? It should be open for any telco to distribute a phone that doesn't have Google as a default setting on it. But that's never going to be enough on its own, because Google can still say, well, I'll pay you money for the distribution of my phone. And the distributor's going to go, okay, and it's got your search on it. Yeah. Well, it might not be a requirement under the agreement. So you might get rid of the requirements under the agreement, but you're not going to change the incentive to sell the phone, because after all, Android is very well known. Android phones work very well. So another thing that Google has done is it's got the benefit of the brand value. It's got the established reputation over and above a competitor that's trying to come in. It's really in an awkward place. So the next thing you've got is the restrictions on manufacturers from what they can put on the home screen. They could put different apps on the home screen. You could withdraw that, and you could say that restriction shouldn't be subject to contractually binding commitments. So let's say we just get rid of it. Well, we got rid of it in Europe in 2018 after the Android case in Europe. It doesn't make any difference, because, if you're the original equipment manufacturer making a phone, and Google says, I'd like you to make it with my apps on it, you're going to go, yes, sir, because you're going to be paid a lot of money to do it. So something more serious needs to be done about default settings and payment systems. We'll see what happens coming out of the DOJ's case on that. Where they're really going, though, is to look at access to the search engine. So a new opportunity exists for people who want to set up and build their own search businesses. Now, a search business involves two basic things. One is a relevance engine, so you can identify that which people are looking for and show it at the top of a search results page. That's what Google did. And the way Google goes about doing that is that it copies hypertext linked pages into a thing called Bigtable, and then it searches against them and ranks them in relation to a quality scoring mechanism that we don't know fully a lot about, but it's a proprietary quality scoring mechanism. And that essentially gives more points, and you get higher up the list if you're more relevant to the questions. So access to that system is likely to be mandated as part of the remedy, so that new entrants can come in, or existing players like DuckDuckGo would be able to expand their capability to be a really powerful search engine, because they could use the Google search technology. One of the things that I've advocated for is that they should also be able to tell people it's Google inside, because that means they need an intellectual property license for the Google brand. I think you're more likely to use a unknown person's product if you know it's got Google inside, because Google's got a fantastic reputation in search. It is a very good search engine. So, but that reputation has been built on the back of ill-gotten gains. So if you're looking at a remedy, then that would be a way of addressing the ill-gotten gains by redistributing effectively the opportunity in the market and lowering a barrier to entry. Because clearly competing against Google, when you're, let's say, Ole's search comes along, nobody's ever heard of Ole's search. But if you say Ole's search powered by Google, maybe you've got an opportunity there to get into the market. And that would need to be for quite a long period of time. So there's an opportunity to create competition in search. We can go in, I don't know what your other questions are going to be, but we can go into some of the issues that are coming up in that case, which are not likely to get resolved, which are going to be a battleground going forward, about access to data and how the data can and should be shared. You know, business data can be shared with competitors so that they can compete. So, for example, opening up the ID, we talked earlier about the double-click ID. Well, it's still there. It's called the Google ID. Google has successively withdrawn access to IDs over the last 15 years. They're still used by Google internally. They're just not available publicly. So there's the Google ID, there's the mobile ID, the MAID, mobile ID, MAID, and they're not available to anybody. So they should be required to be passed on. What they enable is matching the demand for an ad with an ad over an exchange. So again, you know, that would enable more competition to be throughout the supply chain.
I wanted to ask you, Tim, about the not counterfactual, but somehow how would you visualize for yourself and maybe for others the markets which would be more healthy with greater degree of competition, both in ad tech and in search industry? And do we because it looks that significant changes, if both cases succeed, are delegated to the hands of judicial power, whereas from my probably understanding of things, you would need more systemic architectural perspective from the regulatory authorities. What is the role of regulatory authorities in tailoring this new or different or enhancing the existing digital markets? Do we delegate again it to big regulators, or the markets can, after giving this injection of antidotes, become kind of more strong, and they can be governed by the invisible hand more than the visible hand of strong regulators?
This is a massive issue at the moment, particularly from a US perspective. But let me come back to the role of regulators and deal with your first question, which I think is what is really an antitrust remedy, right? What's the counterfactual? Because the law requires, it's like any tort, the law requires the harm to be redressed. So how do you work out what the world would have looked like absent the harm? Well, that's the world, but for the harm. I did a case many, many years ago, a personal injury case on behalf of a lady who was a flautist. She ran into a glass door in one of the big orchestra places. She was late for the meeting, for the rehearsal, and she smashed her face. And she needed to have the ability to play the flute, and it ruined her life. I mean, this ruined her ability to earn money. And it was because there was a new, totally clear glass door with no markings on it at all. And it was negligence, simple negligence. It wasn't designed to cause the problem. So she had a loss of earnings claim. Now, that's one of the first things that happens in tort, which is, but for the harm, what would she have done? Well, she'd have been a successful concert flautist, and there's a future income stream that she would have expected to earn. So one of the things the system needs to do is to look at what the but-for world would be, right? Now, absent all of these acquisitions and absent control of the Google's done something like 300 acquisitions since 2010. Same is true of, look at Facebook. It's bought WhatsApp. It's bought Instagram. Um, Pinterest, all of these companies that were competitors. And how do we know they were competitors? Well, Mark Zuckerberg said so, and that's in another current case, which is in front of the Federal Trade Commission in court at the moment, where the Federal Trade Commission is pressing for the breakup of Facebook. So these acquisitions should be undone and unwound. Now, one of the things that's driving the new administration, I mean, the old administration under Biden was actually pushing for these things as a straightforward application of open markets. They would work more effectively. It would get rid of monopolization of the markets and create competition. Under the new Trump administration, this has got an added twist because it's exactly the same antitrust analysis with the twist that if there were more distributors of content, so if Facebook was separated from Instagram and WhatsApp, then there would be more freedom of speech because you'd have a variety of different voices and an increased plurality of the media. One of the big casualties of the consolidation of the platforms has been the impact that's had on plurality of the media. And plurality means diversity of suppliers. It's not efficiency, it's diversity in a variety of different views being available. Now, we have laws in the UK about plurality of the media. They haven't been used in merger control, which is a shame because what's been said is, oh, well, that's newspapers and social media isn't media in the same way. Well, that's a big mistake, which we now know. Right. But what we've got is a concentration of media outlets, which was never part of the idea. You don't have plurality of the media laws in place, and then you end up with concentration without there being a big mistake on enforcement. That's pretty clear, I think, at this stage. So what that's fueling in the States is we'll break them up then. Right. And the but-for world, had they not been allowed to merge, there would be a separate Facebook, a separate WhatsApp, a separate Pinterest. What we also know is that in a more competitive environment, those suppliers are much more careful about user privacy. So if you go back to 2014 or even earlier, there's a great piece of work done by Dina Srinivasan on Facebook and its approach towards privacy. It was the most privacy protecting social media platform in the late 2000s, competing with MySpace and others until it got to monopoly position. And then it said, we're going to forget the privacy policy. Why? Because data mining consumers wasn't necessary anymore because they had nowhere else to go. Right. So there are lots of benefits from having a more open, competitive distribution market because they don't create the content, they're just distributing it. So more views, more plurality, absolutely on the way. And I think that's probably 100% right from a policy point of view. What does that mean? Well, it means a larger number of smaller businesses will be able to present their stuff across the world more effectively, and that creates a more competitive market. And we are back in the world which was growing faster, which is part of the contribution competition policy gives to growth.
But then obviously a critical
regulation I should come back to because your second part of the question was about regulation.
We will revert to it, to the regulatory kind of top-down approach rather than bottom. But just to ask about how realistic, because this sounds like almost internet nostalgia of good beginning of this World Wide Web mutating into Wild West Wonderland. We know that markets are prone to tipping, or supposedly many studies have indicated, or it's conventional wisdom. Would it be somehow on a temporary solution given necessary oxygen to new wave of competition, which will lead to another consolidation, and then thus next intervention would be required? How do you visualize it for yourself and for others?
Look, I think there's something which is really fundamental that was actually pointed out by Jean Tirole, which should be taught to every competition authority and every economist, right? That if you have a high fixed cost, low variable cost network, which is prone to network externalities, like a telecoms network or a messaging system, there is a benefit to each additional user from being part of the biggest network. That's why from the 1890s onwards, the telecoms networks became monopolies. That's why Facebook Messenger becomes a monopoly. That's why, Apple Message becomes a monopoly. These are communication systems, and you will not have competition if you don't have intervention on interoperability. There has to be intervention to make sure that the market is competitive. Otherwise, it will simply be monopolized. And it always has been, and we've got lots and lots of evidence that that's the outcome. It isn't rocket science to say that. If you look at the proportion of the modern economy which is affected by this, it's everything. It's not just a little sideshow. If you look at the proportion of the economy which is affected by this, it's everything. When you buy a car, a house, insurance, those are the top 3 searches on Google. So the single biggest purchases that any individual makes, they're making through a communications system which is unregulated. Of course, it's going to become a monopoly. That's inevitable. As soon as we deregulated and opened up markets to competition in the early 90s, 2000s, and deregulated worldwide, we didn't decide it was hands-off Wild West. What we said is we were going to regulate them, but we didn't do it. And we didn't do it because, unfortunately, I think that what is taught in business schools and to people learning economics, which is efficiency is a goal. It's an end in itself, right? That what we need is more economic efficiency. We don't. We need more plurality. We need more diversity. We need more choice, consumer choice. And that means we need not just more opportunity at the consumer level as a matter of policy, but we also need more supply. And that means you stop the distributors from monopolizing the distribution system. In many ways, it's just like having a monopoly of draymen, right? In the old medieval world, what you've got is the carriage system being monopolized. Because how else do you see content? You can't see your chosen online newspaper, whether it's the Financial Times or the Guardian or the Times or whichever variety of opinion you want to see, you're accessing it over a device which is controlled by a monopolist that controls what you see, right? And they affect the payment systems. They affect the ability for any of the independent operators, independent suppliers of content to advertise. So they affect what they present. I mean, if you don't have free at the point of use journalism, you don't have any debate, right? If you can't cut and paste, well, of course you can put things behind subscription paywalls, but if you put them behind paywalls, nobody knows what the opinion is. You end up with echo chambers, which is what we've had. So I don't think this is rocket science. I think this was extremely well known, and it's certainly not nostalgic to look back and say we can learn from history. We are not condemned to repeat it. We actually know that if you let these economics simply happen, there will be no competition. There will always be a monopoly. You have to intervene. Therefore, you come to your question about regulation, right? Well, you can do a once every 10 years antitrust case, right, which resets the marketplace. That's pretty ugly because there's a lot of people who've been setting up their businesses who've been harmed in the process. So knowing that you've got the problem, wouldn't it be better to prevent the problem getting worse? So you need much more effective plurality of the media on mergers. So you wouldn't allow a Facebook to buy an Instagram or a WhatsApp or another social media platform. And that wasn't hard for people to spot at the time. There were lots of people complaining that this is going to lead to concentration. It was going to be a problem. It just wasn't done because it wasn't fashionable to intervene in markets. There was a misunderstanding that the market will always give rise to a open market outcome. It won't. It will inevitably generate a monopoly. That's the end state of many markets. You can look at it. It's not just telecoms or communications or technology. It's true of oil and energy networks and water networks. We've got over 100 years experience in all of these markets, knowing they will end up as monopolies because they're very high fixed cost, low variable cost, this huge capital expenditure, and there isn't room for lots of competition. So yeah, you regulate and you intervene. Now, what have we done in terms of intervene in digital markets? You've got the Digital Markets Act at the European level. which is only just beginning to bite, which is a shame. What it should be about is not fining people. There have been 2 recent rather low fines. That's never going to change incentives. And they're set at the wrong level against the wrong parameter, which is a dreadful shame. They should be set against the profit gained rather than a percentage of revenue or something. And anyway, they're so small, they're laughable. So what you need is injunctions. You prevent the harm from occurring. There is a duty on I think, on the public authorities to prevent the harm occurring. You can't just stand by and watch the car crash. That really isn't acceptable. So when Facebook proposes to buy WhatsApp, the answer should have been no. Right? When it proposed to buy Instagram, no. And so it goes on. You know, this is not a set of circumstances which were unforeseen, and it wasn't unconsidered, and it wasn't like there was no inquiry. What we've got is a series of really rather bad mistakes. Now, the CMA, for its, to its credit, actually engaged Lear, the economics consultancy in Italy, to do a report into a series of mergers in the digital markets, and they accepted that many of the decisions were wrong. So I think the first thing you've got to do is prevent the harm occurring. The second thing you've got to do is to look at what's happening in the market and to prevent additional accretive activity. So what do I mean by that? Abuses of dominance should be prevented. We've got yet another example of Google blocking newspapers from being able to do shopping. Right, during the course of last year, they went and they changed their algorithm so that if the newspaper, which, you know, the back pages of newspapers are full of all sorts of things you might want to buy, from knee pads for gardening to Jules Verne journeys across the world. You know, there's the Sunday Times travel section. They've always done this. And what Google said is, oh, no, we don't want newspapers to have affiliate networks for advertising. That's spam, that is. It's clearly not. It's completely bogus. They've been fined, 2.4 billion back in 2017 by the European Commission. And the Commission is looking at it again under the Digital Markets Act. I mean, how long do you have to look at exactly the same thing for you to intervene and say, no, stop it? We're going to fine you again. It doesn't make any difference. It really just requires, maybe what we need is people who do enforcement rather than people who write reports. What you have in the States are people who litigate. They go to court in front of a judge and they have to make that case. And yeah, they do it infrequently and it's subject to political control, which is a problem. So yeah, higher numbers of litigators, more enforcement. Look at the volume of cases that has broken out in the Competition Appeal Tribunal jurisdiction in the UK. There's case after case. There's billions and billions in damages in case after case of people who've been harmed. That isn't an accident. It's a consequence. It's a consequence of a failure to intervene early, because people do stand back and watch the car crash, and then it becomes an exercise in trying to compensate those that have been harmed because they're in the crash. And I find it just appalling that more hasn't been done at an earlier stage.
And in your exposition, or in your understanding of how the planets are moving in the universe, what is the role of the proactive regulation or kind of designing? Because what you've been talking, what you've been referring to, is a more drastic and more vigilant engagement in combating the harms and infringements, and maybe preventing ex ante. But is it enough? A more vigilant, more intense enforcement, or it has to be complemented with also kind of forward-looking tailoring of digital markets? Is it doable? A, and B, do we need it?
I think it's doable, but it requires, if you took a clean sheet, if you look at the organization, take the CMA, take the European Commission enforcement teams, they do a pretty good job with a relatively small amount of resource, right? There's always a small number of people who build up the knowledge. The knowledge of how these technical markets work is first of all a massive barrier. Because if you're going to be an enforcer, you have to understand competition law, you have to understand enforcement procedure, you have to understand the technology, and then you've got to spot whether some of the most sophisticated technologists that you're interviewing are lying to you. Right. So this is not easy to do. But much more effort needs to be put into that and building knowledge systems over time. So, at one point I was general counsel at BT and I had 600 people working for me. And I used to say to people who joined the team, well, you've got a law degree, you've got some experience, because we take people on who are just qualified. And I said, in 3 years' time, I would expect you to start being useful, because it takes that long to understand how the technology works and to spot whether somebody is, telling you lies, right? It does take quite a bit of experience. So, I think the building of that experience into people who are honed, and who have the experience of losing and winning, that understand that putting a case together is one of the hardest things you can do as a lawyer. It requires creativity, but it also requires enormous strength of mind, because what you have to do is to line up a series. The system is based on legal systems that essentially at their heart are innocent till proven guilty. So you have to prove the claim, you have to assemble the evidence, and the person you're proving a claim against is the one with all of the evidence, because there is a total lack of information in the marketplace about what they did and how they did it. And they have a massive incentive to lie to you because they make a huge profit. Personally, the individuals are off to on earnings per share bonus schemes. So they have a huge incentive to not tell you the truth. So yes, it's hard, but it requires, I think, an assessment of the type that I think the Department of Justice and Federal Trade Commission do it pretty well. They have multiple teams, they have more resources, but they are built in a way from the ground up. I was at give you for example of the sort of thing that an ex-CMA person told me recently at an event. So the difference between the people at the CMA and the people in Washington is that if you are a detective or an investigator and you're grade 1, that means you've just started doing the job, and you do the same job for 5 years. In the CMA, you don't get paid any more money. You're just doing the same job for 5 years. In the DOJ, you're detective grade 5, because you are better at your job because you've done it longer and you've got more experience. And I think that that's a really simple thing to say, but it's quite a hard thing to do in a civil service, which is to change the way in which you reward people. You change the sort of people you need. They really got to start with litigation experience if they're going to sue people. And they have to be really good, because they're going to go up against the best in the world that are financed by the monopolists. So that's hard. I mean, I think in the short term, what you do is you employ, people who specialize in the area from the big law firms. Or, I mean, I was at a big law firm. I was at Sidley Austin, but, or the smaller law firms like where we are at the moment, because we're doing enforcement, but we're doing as many, if not more cases than the public authorities. And it's a puzzle to me why they don't just reach out and use people like us. Second thing I would do, so that's the legal capability. But my knowledge of the technology is refreshed every day because I work with a team of technologists. We set up the movement for an open web, which has a large number of computer scientists and people who've got way more experience than I have in the detailed workings of the technology and advertising and publishing markets online. And you have to be on top of that daily. You can't just dip in and out and have somebody that's dropped in, to do, the civil servant that spends 2 years in the Department for Business and Trade, then moves to, the CMA for a couple of years, and then no, that's not going to work. You really need to understand the detail and have relationships with people who are going to be good witnesses, that you have their confidence, that they know that when they put a complaint in front of you, you're going to prosecute it. That takes time to build. As I say, I think the DOJ does that quite well on the FTC. For example, they will interview you without being on the public record. Right? Why? Because they want to know what to look for, because they're going to go and get documents. I frequently go to public authorities in Europe and here in the UK, and I say, look, I'll tell you what I know, but I think what you need to do after this is to go and ask the defendant for the documents that relate to this, because that's your best evidence. But they don't do it because it's not part of their DNA. It's not part of the way you do things. They do a request for information, right? And then you get an answer to the question, which is, no, I don't think so. Or, no, what you want is the documents. Give me the documents, because the documents are much harder to spin, right? So, you've got to look at disclosure by inside the authority. That's my second point, is about how you get to stuff and what you're looking for. And I also think, my point about using externals, I think it's a mistake to use experts in-house in anything. When I'm running a case and I want to get an expert that can tell me about the tire tracks on a Mark II Jaguar from 1962, I can get that expert, but it's always external, right? You need experts that relate to your evidence. So, I mean, I don't know what the value of having a huge internal technical team or an internal economics team is. I would, maybe they can help identify, translate, and work through the evidence from external experts, but I would use external experts a lot more, because you can get them to come in and support and provide advice and information. It's very, very difficult in monopolized markets to find anybody that's, that hasn't had a previous history with one monopoly or another, though. So maybe that's the reason why you have to have, internal people. But if you're not shopping in technology markets for the expert in, payment systems or video codecs, they're all different people. So you do need quite a range of technologists, and you need to talk to the competitors. You have to be much more open to smaller competitors being your treasured supplier. I work with lots of small businesses. They are so busy. They've got a business to run. They're desperate for cash. All of them desperate for trying to make money. And the last thing they need is somebody just sitting there in an authority saying, "Thank you very much. I'll get back to you." Enthusiastic engagement is critically important to get busy people's attention and to prosecute in the public interest. And I think that's missing at the moment.
My next question, I know we are approaching the end. My next question is probably a little bit redundant, because based on your previous answers, it becomes quite clear what would be your next answer. But yet, let me just to position better your philosophy, regulatory philosophy. There is a cluster in this digital market regulatory landscape who think that, okay, we designed rules which can bite DMA, DMCCA potentially in the medium term perspective, and we've got discretion. We can interpret them overly strictly, and yet we have flexibility. We can turn blind eye, and thus we have this kind of bargaining chips for the regulatory dialogue, where we can come along and tell the gatekeepers, guys, please don't circumvent, not only from the perspective of law, but also from the perspective of technology. Do in ABC, and we will be much more lenient in EFD, whatever. The other cluster would say it's complete naivety, again, idealism, but because when the money is at stake, where power is at stake, and such competences are still disproportionate, maybe slightly less disproportionate, but yet the skills are much stronger in hands of the gatekeepers. Nobody would be doing it seriously. You will be just ridiculed, and adversarial model is the only one which works. I imagine you would subscribe to the second model, but I don't want to somehow prejudge, and please highlight your view on both.
So working for a regulated industry in the UK like British Telecom, and working with regulators across the world when we're taking cases, working with the European Commission in the late 90s, early 2000s was an absolute joy, because they were keen on prosecuting and taking cases and opening up markets and creating growth and competition, and they could see the benefits, right? And markets boomed as a result. I mean, it was a fantastic time, and it was very successful and the people were very engaged, and it was a lot of fun, right? And I think that needs to be, this is a business observation. The people leading those organizations need to focus on the fun, right? It's not an administrative exercise. This is actually creating opportunities for consumers to buy things and do things that they want to do. So the consumer friend should be actually engaging in a joyous exercise. This should be absolutely fantastic. It's not a dull administrative task. And what you want is people who are enthusiastically getting up 5 minutes earlier every day so that they are doing their job to the benefit of, it's a public interest goal. And that's a fantastic thing to be. That is not what I see, right? What I do see is that it can be like that. It depends on the management. It depends on their vision. It depends on what they prioritize. So at the moment, much of the priority of the millions of pounds worth of public enforcement money is spent on merger control. Well, you could reprioritize that and you could spend more money on enforcement. More money on enforcement in teams that know what they're doing, right? So that you take more cases, but decentralize the control. So one of the first things that I would suggest authorities should do is to tell their constituents, their stakeholders, their politicians, their parliaments, we're going to lose a few cases. Why? Because you're not trying hard enough unless you use a few cases against trillion-dollar companies that employ the best lawyers in the world. Of course, you're going to lose a few. Why would you expect to have a 100% record? The European Commission's got a 100% record. It's not trying hard enough, therefore must be the case, right? There has to be much, release the handbrake and the control over people taking cases. I would decentralize. You don't need big teams to take these cases. You need well-informed teams with experience, so you can do things in a far more decentralized way with groups of people that are engaged in what they're doing. I talk to a lot of barristers that are dealing with the cases that are created by the authorities. They're engaged far too late in the day. They don't help formulate. I mean, I'm a barrister, but I help formulate the case because I don't want to lose it. So if you get given a case that you didn't help formulate, you can present it to the best of your ability. But if you didn't help formulate it in these markets, you're not got as big a chance of winning. So I don't think that regulation is pointless. I think regulation can be very effective, but it isn't currently being organized in that way. That's my first point. Secondly, yes, of course. If your management team in Apple, Facebook, Google, Amazon, whatever, are incentivized on maximizing profits as they are, they're going to give you the runaround. I noticed that today Apple has received a criminal indictment from some judge in America for not telling it the truth. Is this rocket science? Is this hard to predict? No. Of course they're going to get lied to, or they're going to be equivocating, or they're going to be shading the truth, or they're going to be spinning the truth, or they're going to use language which misleads. Of course. I mean, why would anybody think anything else? I mean, it does raise questions about the whole idea that anybody came up with principles-based regulation. From a rule of law point of view, I think the idea that you suggested, which I just want to pick up on, is very dangerous and quasi-corrupt. If the authority says, I'm going to take these cases, but not these ones, the authority is not enforcing the law. And we need to have a system which has respect for the rule of law. If you look at what's happened over the last 15 years, the law has become a joke to a lot of people in technology sectors. So they don't respect it, and the compliance becomes much more difficult. You've got a generation of people who've got away with making a fortune out of exploiting others, and that's really, really bad behavior, right? It's not sensible business behavior. It's not providing better products that work better, solve the problems more quickly. No, it's about monopolization and leverage. And that's a bad outcome for what could be a competitive market. So I don't think this is good competitive markets satisfy users' needs in ways that actually and consumers' needs in ways that benefit them. They also give people life-enhancing roles and jobs, don't they? I mean, you're doing something useful that other people like. Fantastic, right? But at the moment, what you've got is people spending their time playing games with regulators, avoiding, providing things to people that they want. I mean, we've seen evidence come out in the recent trials where, many have said, well, the problem we've got is our product is rubbish, right? If you look at the Google search page, 80% of it is advertising. Well, actually having a search engine that mostly produces results that are relevant to users might be a good thing to be doing if you're making search engines. I mean, if you're in the business of making cars that work well, that's a joy. So actually, I think this system that we've got in place at the moment is giving rise to all sorts of very dangerous outcomes, and they affect. I said earlier, this makes a difference to the price of a pint, right? Well, it does, because competition makes a difference to the price of a pint, but it also makes a difference to the structure of the high street. It makes a difference to what you see on the high street. It makes a difference to who competes where, what their available opportunities are. Because if you suck in all of the available commerce for everything that you buy to online suppliers, that's changing the shape of the physical world. That's actually changing people's opportunities for jobs locally. It's sucking activity to different parts of the world. That makes a difference to the entire economy. So this isn't a small issue. It isn't something where a regulator in any jurisdiction should be saying, oh, I'll let you off on these and I'm going to investigate that. No, this is far more important than that. You need to nail every single thing that you can find, because you know that you're only going to see a small number of the things that are the problem.
My
Thank you for
last
your
question
provocative
before
question.
yes, you did. Before reverting to inviting you to offer recommendations to students and maybe to academics who deal with this matter, is more factual, related to publisher industry, which been for decades the leader and pretty much trendsetter in the business of advertising. And then when online advertising emerged, they are losing their impact.
Shirt.
So I wonder if there is any. Do you see that they are more focused on compensatory kind of mode, or there is necessary skills and desire to develop something which would be an alternative? Is there any alternative to the double click and original model and its kind of current Google focused module exists? That was a question similar to the one I asked about the regulatory cycles and breaking up monopolies and then waiting for another one to emerge. But do you see any alternative model, or it will be pretty much the same with tiny nuanced refinements? And will, in this alternative model, the role of publishers maybe consolidating somehow without any intermediaries be higher?
I think if you look at the written word and the ability to communicate complex problems in writing, scientific journals, complex academic papers, things of that type probably always need to be reduced to writing in written form, because the nuance and the sophistication of the idea can be expressed very precisely, and the reader can go back and check and make sure that they understood the specific. If you look at the growth of video, short video, whether it's TikTok or YouTube, or they're frequently used for communicating solutions to problems in ways that people are now using as search tools. So I don't think the world ever stands still, and I'm certainly not advocating for going back in time to any period. I think if you look forward, what is Snapchat, Pinterest, Instagram will evolve. What we're seeing is higher levels of communication using video, which then enable people to understand more quickly, because the video can communicate more quickly. So I see it, certainly you see that at the moment with the way that a lot of people are using those particular platforms. And the provision of the content doesn't need to be completely locked into the provider of the distribution system. So different separations between what you could think of as media organizations. The BBC is a media organization, or a television channel is a media organization, and they create curated content. Now, clearly, they are operating within a broadcast medium, but you can do much the same thing online, and I think that's evolving. I think those are all evolving over time. Now, clearly, give you an example of that. Recently, people used to watch films that were between an hour and 2 hours long. Now they watch huge volumes of box sets, which stretch the story out over time. Whether you like it or not, they're popular, right? So there are different formats: short video, long video, film video, media content, curation. You see I think there's a lot of variety in all of that. If you have controlled distribution, that affects all of the freedom of speech, plurality of the media problems that are being identified. I think that will open up. I think that's likely to open up now. The US is on that case, and they will break the companies up. I think search will evolve. We haven't talked about AI. I think at the moment, AI overviews are obliterating the opportunity for a variety of different choices to be effectuated, for choices to be made by consumers, because they're being supplied with something that one of the AI players offers, and that's it, right? So that's another quasi-monopolistic activity, and I know the DOJ is keen to prevent the existing platform owners just segueing their existing monopoly into the next wave of large language model AI based systems. So yes, that is that's a problem at the moment, but it's also a solution, because there's lots of different AI models. There's lots of different ways of using computing. Maybe that doesn't quite need the same level of computer resource that's being deployed at the moment. Sheds and sheds and sheds full of servers that are called cloud computing platforms that are used in order to enhance a particular, I can only think of it as wholesale breach of copyright law worldwide. I think that is in the process of being, we're early stages for a new industrial structure where the courts aren't really, they're always so slow by comparison with technology developments, that there will be landmark cases that are being developed. I mean, I don't know, there was 35 cases the last time I looked against AI models in the US. This is not a new fantastic development without problem. It is a new fantastic development which cuts across multiple different rights held by different people, and that is something where there is a conflict already in process that needs to be resolved. So no, I think the world going forward, yes, there's a huge role for regulators, but they need to be extremely well informed, and that isn't a have a look on a case by case basis. This is kind of a thing you have to do for quite a considerable period of time. You have to be engaged with networks of technologists and experts, roles for academics and people in universities and the like. Absolutely should be part of the outward looking, outward facing new approach towards regulation. I think that's vital. I think they don't stand a chance of understanding what's going on otherwise.
This is really, really, really informative conversation, Tim. I really hope that we will have an opportunity to engage in your analysis of the next development in the next phase, and we will have it more or less periodically, these conversations.
No,
I wanted to
delighted.
finish today's one with inviting you to share some useful, not just wake up earlier, work harder, and remember that competition is everywhere, but some maybe useful suggestions for those who are newcomers in this business, and they have huge privilege to learn from the first wave of antitrust lawyers dealing with tech business, and they are probably more advanced in terms of using or having digital technology in their daily routine and thus sensing it better. But how would you channel their maybe last 2 years of university to do most out of it and to prepare best for this profession?
Oh, it's a hard question. I think one of the things that we often think is that technology in the past is just in a history book, right? And therefore it can be safely ignored. The reason I explained the 3 different layers is that much of the technology that we use today was built 100 years ago. You can't use a mobile phone unless you use a 100-year-old telecoms network and a 70 or 80-year-old radio communications network, right? And all the sites and towers and spectrum and all of that knowledge, it's there. And if you understand that, you can understand the next stage. If you don't understand that, you're building on sand. So I think it is very important to understand the technology. I had one of the guys that worked for me here in practice went off and did a computer science degree as a result of working here. But I don't think you need to go that far. I think you can actually look as you say a practical example. The most comprehensive study of technology markets that I think has been done was the CMA's digital market study of 2020. It's brilliant. And it summarizes how everything works in a very intelligible, easy to read way. It's quite long. Sorry about that. But it is extremely useful because it's identified probably all of the problems. It is a bit long. So, as I say, apologies for that. But that's very, very good. I think the CMA does incredible analytical studies, which are much better than anything you get out of the Commission or anyone else. Because they go away and they do proper detailed research and they interview lots of different people and their conclusions are normally pretty spot on. So I think CMA market studies are, if you like, a quick cheat, as they take a while to read, but they're a very good source of understanding what's happening. And they also do it in quite a nice way because they start with an executive summary and they then take you through so you can go into more detail depending on what you're looking at. So don't be too put off by the size of some of those reports. I mean, the other thing that you can't say this really, insatiable curiosity. There is no substitute for being curious and asking questions. When people say to you, there are just no stupid questions, there really aren't. Because if you don't understand it, it's probably because somebody hasn't explained it properly to you. And if you start with that as a proposition, I think that's really, really useful. These days, what I find with a lot of people is that they seem to be embarrassed about speaking up about stuff or not, don't want people to know that they're dumb because they ask a dumb question and worried about the derision of other people. Maybe it's just I'm used to the derision, but I think, there needs, people, young people particularly, should realize that it's okay for you not to know things. And if you don't understand it, keep asking. And the fact that somebody else is rolling their eyes and giggling or something, it doesn't matter. You need to be able to just, go and ask the question. And you can learn a lot by going online, checking questions out, doing research. If you don't understand it, first, second, third time, check it out, research it, go back and ask somebody else. And frequently, if you ask the question of people, that they may be able to help. So, don't be embarrassed to ask. I hope that's useful.
Absolutely. Tim Cowen, thank you very much indeed for
It's a
this
pleasure.
conversation. It was a real pleasure.